policy statement, issued a formal policy statement regarding the profession's stance on abortion and reproductive health. Quote, every individual within the context of her or his value system must have access to family planning, abortion, and other reproductive health services. Again, most social workers, the data suggests, agree with that statement. I want to acknowledge that some social workers do not. In my experience, there are 5 overriding major ethics and risk management challenges associated with today's topic. The implications of the Dobbs decision for social workers. First, issues related to client privacy, confidentiality, and privileged communication. Those are not synonyms. When clients choose to share private information with their social workers about their reproductive health decisions, then of course, social workers are obligated to manage that private information in accord with prevailing standards in social work. In the Code of Ethics, section 1.07. It's a very long section. Now, the guidelines concerning management of confidential information and exceptions to clients' right. And then there's privileged communication. And as Chris and David will attest, I think, privileged communication is a narrower phenomenon. It refers to the management of confidential information during legal proceedings. So, for example, if hypothetically a social worker's client is prosecuted in a state that allows prosecution of a woman who seeks an abortion, and a social worker's records get subpoenaed, decisions about disclosure, challenging the subpoena, all of that falls under privileged communication. That is the management of clients' sensitive, confidential information during legal proceedings. Second, the challenge of digital footprints, digital trails, which I'll get into in more detail shortly. Lots of very complicated issues. I mentioned that fairly recently, several colleagues and I were asked by NASW to revisit the code written by the task force that I chaired in the 1990s for the sole purpose of adding standards related to technology. We added dozens, and I mean dozens of standards related to the way we use technology to communicate with clients, to store electronic information, to provide services remotely. When I had the privilege to draft the Code of Ethics in the 1990s, the phrase digital footprint did not exist. The concept of a digital trail did not exist, but it sure does now. And as I'll discuss shortly, digital footprints and digital trails might expose clients and by extension their social workers to some risk when social workers provide services related to abortion, reproductive health. Third, documentation issues. As David and Chris know very well, our documentation of the services we provide, the discussions social workers have with women and their partners about abortion, those documents can be subpoenaed. Courts can order disclosure. So we have to make sometimes some very careful decisions about what to document, how to document, given who might have access to those records down the line. Fourth, I want to say a little bit about what lawyers call abandonment. It's a legal term referring to instances when social workers either terminate services prematurely, are not available to meet clients' needs, considering current standards of care. And I want to talk a little bit about the challenge some social workers may face when they feel the need to refer a client to another social worker, for example, for assistance regarding an abortion-related decision, particularly if the referring social worker is not comfortable talking about abortion for faith-based or other reasons. Ethical issues involving termination of services to a client who wishes information about an abortion decision. And finally, I have a lot to say about what we can do to protect social workers in three regards. I'm anticipating the possibility of civil litigation where social workers are named as defendants in association with the services they provide related to abortion and reproductive health. I'm anticipating the possibility as time moves on that social workers may be named in licensing board complaints alleging that they failed to adhere, for example, to state law regarding discussion of referral for abortion-related services. And while I don't think it's statistically likely, I think we need to acknowledge the possibility in some states that providers, primarily physicians, OBGYN, may be prosecuted. I trust many of you, if not all of you, have followed what's been going on in Indiana as a prime example. Well, in some of the cases, social workers may be involved. So I think we cannot be naive about these three forms of, as lawyers would say, exposure: civil litigation, licensing or complaints, criminal prosecution. Now, some of you may have heard yesterday on National Public Radio, talk about timely, a rather lengthy piece, 11 minutes, it's extraordinarily long in radio, on a Texas couple who faced a very daunting set of circumstances when this woman, you see in the photo there, when her membranes ruptured, it looked like, was going to lose the fetus, and under Texas law, was not permitted to terminate that pregnancy. Now, I just want to play for you, and I hope the technology cooperates. I want to play for you just about 3.5 minutes of this. And as I play this segment, I'd like you to think about the potential implications for a social worker working with this couple. So hypothetically, this couple who's in deep distress around this now problem pregnancy, suppose they consult you, the social worker. I would like you to think about the ethical decisions you might need to make. All right, so let's see if the technology cooperates. A thumbs up, Dave or Chris, if you can hear the audio.
All of Roe versus Wade is doing more than banning or restricting abortions. It's also having serious impacts on pregnancy care. The abortion bans in some states are so new and often so ill-defined that doctors and hospitals don't know how they apply to complications. NPR's Carrie Feibel brings us the story of a woman in Texas whose pregnancy took a sudden turn, and because of the state's abortion law, her case became a medical crisis.
This story was never supposed to be about abortion. It was supposed to be about pregnancy, a pregnancy that Elizabeth and James Weller had been trying for.
It took immediately, and we were really pleasantly surprised by how quick it happened.
The Wellers live in Houston. She's getting a graduate degree in political science, and he teaches middle school math. At 17 weeks, they found out they were having a girl, and the anatomy scan showed everything looked great.
There was nothing wrong with her, no development issues wrong.
A week after that scan, Elizabeth went for a walk after breakfast. It was May 10th, weeks before the Supreme Court would overturn Roe v. Wade. But in Texas, things had already changed. Most abortions after 6 weeks were banned. Elizabeth didn't think that could affect her. They were going for it. They were setting up the nursery. But when Elizabeth got back from her morning walk, she felt something shift inside.
This burst of water just falls out of my body. And I screamed because that's when I knew something wrong was happening.
James rushed home, and they drove to the ER at Houston Methodist Hospital in the Woodlands.
And I asked the technician, I was like, is she okay? And she goes, well, it's kind of hard to tell because there's very little amniotic fluid. At the time, I had no idea what that meant.
It was premature rupture of membranes. Her waters had broken too soon. It happens in about 3% of pregnancies. If it's later in pregnancy, sometimes doctors can delay delivery, give the fetus more time to develop. But sometimes the baby is born far too early and dies, or is born with serious disabilities. Elizabeth was admitted to the hospital, and later that night, her OBGYN called to talk it through. She was 18, almost 19 weeks pregnant. There was still a fetal heartbeat, but it could stop at any moment. The watery cushion of amniotic fluid had disappeared. That also meant the lungs in the fetus would stop developing. Her doctor said one option was to try to stay pregnant, although this could be very risky and would likely not work.
And she says, let's say if you get to the week of viability, which is around 24 weeks, I can't promise you that she will continue to live past that point. And because there's no amniotic fluid left, she's no longer going to be a developed baby.
Elizabeth's doctor wouldn't do an interview for this story, but Dr. Alan Peaceman, a maternal fetal specialist at Northwestern University's Feinberg School of Medicine, says the chance of a fetus surviving in that state from 18 until 24 weeks is virtually zero.
It's almost inevitable that the pregnancy is going to be lost anyway. And many women would say, why do I have to continue to carry a pregnancy that is doomed? And that's a huge psychological burden.
Prolonging the pregnancy also meant Elizabeth could develop a serious or even life-threatening infection in her uterus. So her other option was to end the pregnancy. Elizabeth was distraught and heartbroken. She could never have imagined making that decision, but now she felt continuing the pregnancy was wrong. It felt scary and also cruel.
You have to ask yourself, would I put any living thing through the pain and the horrors of having to try to fight for their life the minute that they're born?
James was in total agreement. But the next morning, they learned it wasn't their decision to make. The Texas law was making it hard for her OB to arrange the procedure.
I remember hearing her from my room speaking loudly about how nothing is being done here.
Her doctor came back to her bedside. Elizabeth says she looked defeated.
And she starts to cry and she tells me, they're not going to touch you. And that.
So I'm going to stop it there. And I share this with you, a very painful segment from NPR. I share it with you because I think it illustrates with one example how complicated both the ethical and legal issues are, potentially involving social workers. So as I said, imagine hypothetically, this couple comes to you, the social worker, you're working in a healthcare setting, and they want you to help them think through what their options are. And they understand that they can't end this pregnancy in Texas, and they ask you, social worker, to help them find a state that would permit them to abort this pregnancy. So now your fingerprints are on this, figuratively speaking. Your notes indicate that you helped facilitate referral to another state to abort this pregnancy. So that's just one example. And David and Chris, I don't know if you want to say anything at this point. This is just an illustration. I don't know if you want to add any thoughts here or just wait. I'll leave that up to you.
Dave, do you want to jump in? No.
With regard to the issues that social workers ought to be thinking about in this sort of situation, again, to protect client, but also to protect themselves.
Well, I would just say any social worker has to be aware of the law in their state. I think that's the place that you have to start. You don't have to be a lawyer, but you do have to know about what the law says specifically, and perhaps even consult with a counsel in that state that can advise on the law. You know, what does it say specifically about, you know, whether it's unlawful or illegal, because it could be two different things depending upon the wording. And also what, you know, they say about anybody who's facilitating. Are they referring to just doctors, or are they looking at, you know, people who, you know, make the referral? So that's the first place I would say start.
Yeah, I would echo that. You know, really what you want to know is, does the state law in question prohibit sharing information, which is at a minimum what the social worker would be doing, that includes abortion, Or does it require more? Does it require steps in furtherance? I don't know. You would want to know by researching the law yourself in that jurisdiction or getting competent local counsel to help you think it through.
So I agree completely. And hypothetically, I can imagine, again, hypothetically, that this couple might say to the social worker, we are so distraught, we are so raw. Would you please contact colleagues in other states and see if you can locate a facility that might be able to help us? So now you've got on your smartphone or your office phone evidence that you called another state, to use David's language, in furtherance of. And state laws vary tremendously on these issues. So that's just, if you will, a little hors d'oeuvre with regard to how complicated these issues are. Thank you, folks. So let's move on. One of the issues, both ethical and legal, that we need to think about is HIPAA. All right, so everybody's familiar with HIPAA. 1P, not 2Ps. I can't tell you how many times on students' papers I have to correct it. It's not HIPPA, even though it sounds that way. HIPAA, Health Insurance Portability and Accountability Act. And I've encountered some social workers who believe that clients control the release of that information. Well, in my opinion, again, Chris and David may want to weigh in on this, HIPAA governs release of information by the provider, not the client. And a client cannot necessarily hide, so to speak, behind HIPAA, which does not provide a complete block to disclosures. HIPAA has exceptions. The social worker and their business associates would be prevented from disclosing any protected health information, PHI, unless they fit within a HIPAA exception. So I think social workers working in this arena need to know what those exceptions are. And here they are on slide 7. So it may be that a social worker would be permitted, not necessarily obligated, but permitted to disclose. And this is what I'm showing you here is drawn right from HIPAA. Law enforcement warrant, subpoena, court order. I won't read all of this, but it's legalese having to do with a so-called administrative request, for example, including an administrative subpoena or a summons. You see a number of other provisions there, law enforcement inquiries, that sort of thing. Disclosures to prevent imminent and serious threat. HIPAA absolutely permits that. And what I think social workers need to know is that some states within the last few weeks now have laws, recently signed by governors, literally within the past few weeks, prohibiting release of PHI, protected health information, related to reproductive services without client consent in response to out-of-state judicial requests. So hypothetically, and Chris, David, again, weigh in on this, please, if you'd like. Hypothetically, a New Jersey social worker who helps a client locate, New Jersey may not be the best example, say a Texas, because the laws there are so strict. A Texas social worker who helps this couple find a facility in another state. And there's this out-of-state judicial request for information about those social work services. I'll give you an example of a recently signed state law on this very issue. And there are several of these that I could show you. I'm just going to pick one. So this is Connecticut. And in Connecticut, HB, House Bill 5414, provides legal protections for Connecticut residents and healthcare professionals seeking or providing reproductive health care. And I won't read this whole thing, but if you look down here, it says that the law prohibits state agencies and healthcare providers from assisting in out-of-state investigations or prosecutions of reproductive health care that's legal in Connecticut. So you can't cooperate with another state that meets these criteria. Anyone, the last bullet point, anyone being sued in another state for allegedly providing or receiving support for reproductive health services that are legal in Connecticut can recover certain costs they incurred defending themselves. And so I've seen a number of states where governors have signed laws, bills, with similar sort of language. Chris or David, anything on that before I move on?
Yeah, I would chime in happily. On July 1st, Governor Murphy signed 2 bills into law relating to this. The first of them would generally prevent the disclosure of a patient's medical records relating to reproductive health care without the consent of that party in any civil, probate, legislative, or administrative proceeding. And it would also prohibit public entities and employees from cooperating with interstate investigations aiming to hold someone liable for seeking, receiving, facilitating, or providing reproductive health care services that are legal in New Jersey. It's New Jersey's equivalent of Connecticut's Safe Harbor Bill. Secondly, a second bill was passed that would prevent the extradition of an individual within New Jersey to another state for receiving, providing, or facilitating reproductive health care services that are legal in New Jersey. So Connecticut, New Jersey, and a growing number of other states are basically saying, we're not going to entertain your out-of-state subpoenas. You don't even need to come to court to quash them. They're just not going to be entertained as a matter of our state's law, which is very positive for us in New Jersey, Connecticut, and so on. It's cold comfort to those people in other states where that is not the case.
Right. And this is just, I think, a great illustration of why it's so important to know your local laws. Because first of all, these laws are emerging rapidly and they're not uniform. And there are some states where I predict these laws will not exist, right? Chris, I don't know if you wanted to add anything to this.
Yeah, just 2 things. One, even outside of this, and this is, when states are passing these laws, these are really important. So encouraging this in as many states as possible, I think is good social work advocacy. But even outside of this, generally, if somebody from one state wants to subpoena somebody in another state, there's a procedure that you have to follow. You have to kind of get permission from a court of appropriate jurisdiction in the state where the person resides, the person who's being subpoenaed in any way, where that person resides. Okay. And, so there is a procedure. And then that leads to my second point is that if anybody does, have to deal with any of these things, not to act immediately. Okay. First of all, subpoenas, look, Dave and I can tell you, we do subpoenas all the time. We're talking mostly about things that lawyers put together and send out, and sometimes even knowing they may not get anything. Okay. Court orders are different and a law enforcement warrant is different. But when, we get those, sometimes people panic. Oh my God, I have to comply immediately. And the opponents of these subpoenas or these documents may say same, and that's not true. Okay. The person does have the right to consult counsel, to have some time to, find out what their rights are, to consult with their client. I mean, so slow down if this happens to you and call a lawyer as soon as possible, and don't be intimidated.
And thank you, folks. Perfectly timed comments. And I would add just 2 things. One is, and I'm sure many of you know this, but I still encounter social workers who don't fully understand the difference between a subpoena and a court order. So you get a subpoena, they are typically worded as follows. You are hereby commanded to ... That's the standard introductory language. You are hereby commanded to. They don't say, if you happen to be in the neighborhood and you're in the mood, please stop by and hand over these documents. It says you are hereby commanded. And understandably, social workers who are not trained in the law can be intimidated by that and respond too impulsively. That's point number 1. Point number 2. Please, if you're not familiar with it, take a look at the language in the NASW Code of Ethics, Standard 1.07J. 1.07J basically says, I'm going to paraphrase, if you're subpoenaed, you are not allowed to disclose documents or other information without client consent or a court order. If you don't have client's consent, your duty is to challenge that subpoena, is to talk to a David Barry or a Chris here. You file what's called a motion to quash or what's called a motion for a protective order. And that's our obligation as articulated in 1.07J. And sadly, I encounter some social workers who are not familiar with that. So David or Chris, anything on that before I move on? Okay. We're on the same page. So a little bit more about HIPAA. Regarding disclosures to prevent imminent and serious threat, which again is explicit in HIPAA, that is a permitted disclosure. Under HIPAA, as it says here, providers are permitted but not required to disclose a client's protected health information to law enforcement if the provider believes it's necessary to prevent or lessen a, quote, serious and imminent threat to health or safety. And all social workers are familiar with that kind of language, all right? So I think it's important to know that even if you think a client's health is at risk, you're not required to disclose that. Permitted, yes. Required, no. Now, the Federal Office for Civil Rights. The Federal Office for Civil Rights, OCR, is the federal agency that oversees HIPAA enforcement, HIPAA compliance, OCR. And according to the Office for Civil Rights that oversees implementation, compliance, enforcement of HIPAA, disclosure of information to law enforcement, look at these words on this slide, please, the second bullet point. Disclosure of information to law enforcement would be inconsistent with professional ethical standards as it comprises the integrity of the patient-client professional relationship and may increase the risk of harm to the individual. Now, some of you may not know that the federal government has publicized this language recently. This is incredibly recent. So let me show you the document for those of you who want to follow up. Whether this would have happened in the last administration, don't know. My personal opinion is I doubt it, right? Elections have consequences. This is the document released by OCR, Office for Civil Rights. Look at the date on this. At the bottom, it's somewhere here. Sorry about that. I went to the footnote. It's June. It's there somewhere. June 20. I mean, that's how recent this is, folks. So let me say it again. The Federal Office for Civil Rights, which is part of Health and Human Services, issued this document, HIPAA Privacy Rule and Disclosures of Information Relating to Reproductive Health Care. And this is the document that says that under a number of circumstances, disclosure would be inconsistent. They don't refer to social work ethics standards, but in my opinion, included in here. So this is a really important document to be aware of. And in that regard, this document actually provides several examples. This is several weeks old, folks. Several examples under their guidance. Department of Health and Human Services. An individual goes to a hospital emergency department while experiencing complications related to a miscarriage during the 10th week of pregnancy. A hospital workforce member, let's say social worker, suspects the individual of having taken medication to end their pregnancy. State or other law prohibits abortion after 6 weeks. This is the hypothetical. State or other law prohibits abortion after 6 weeks of pregnancy, but does not require the hospital to report individuals to law enforcement. Where state law does not expressly require such reporting, the privacy rule, HIPAA, would not permit a disclosure to law enforcement under the, quote, required by law, unquote, permission. Therefore, by the way, this is not my paraphrase. This is the federal policy. Therefore, such a disclosure would be impermissible, not permitted, and would constitute a breach of unsecured PHI, protected health information, requiring notification to HHS, Health and Human Services, and the individual affected. So I would say, as a social worker, that's good news for our team. David and Chris, let me just, if you don't mind, let me just review these two other hypotheticals and then offer the two of you an opportunity to comment on these, if you would. Number two, a law enforcement official goes to a reproductive health care clinic and requests records of abortions performed at the clinic. So again, picture a state that's likely to aggressively prosecute abortions. If the request is not accompanied by a court order or other mandate enforceable in a court of law, the privacy rule, again HIPAA, would not permit the clinic to disclose PHI in response to the request. So you get this very aggressive request by law enforcement. What this is saying is the rule would not permit the clinic to disclose PHI in response to the request. Therefore, such a disclosure would be impermissible, not permitted, and would constitute a breach of unsecured PHI, requiring notification to HHS and the individual affected. Third scenario, a pregnant individual in a state that bans abortion informs their healthcare provider that they intend to seek an abortion in another state, the scenario we were just talking about, where abortion is legal. Picture that Texas couple. The provider wants to report the statement to law enforcement to attempt to prevent the abortion from taking place. So hypothetically, let's say you have a provider in that couple's home state, let's say Texas, who for faith-based reasons or other reasons objects to their efforts to go to another state to abort this pregnancy. So the provider wants to report the statement to law enforcement to attempt to prevent the abortion from taking place. However, according to DHHS and the Office for Civil Rights, the privacy rule would not permit this disclosure to law enforcement. So let me pause there. And David, anything you want to say about these scenarios?
I would say that the guidance boils down to this. The Office of Civil Rights is going to deem you're turning over such records to law enforcement or other requesting authority a HIPAA violation if it was not backed up by a court order. Okay, so or the equivalent from an administrative agency. So the guidance from OCR, the way I interpret it, is saying you can't just turn it over. You must require a court order or the equivalent before you can do so. Otherwise, you're in violation of HIPAA. And friends, those penalties are significant.
And not only are they significant, if we had more time, I would show you the federal website where many of these unauthorized disclosures are posted for public consumption. So, Chris?
Yeah, just briefly, in the first one, I agree with everything that you and David are saying. One of the things that I would, just practically tell people is that if, they were to encounter something like this, they're obligated to assert, these guidelines, assert privilege, okay, and refuse to provide them. Sometimes law enforcement is going to say, I don't care what you say, and they may kind of push through. We cannot stop them. The advice would be don't try and stop anybody physically, right? You do have the right to whip out your phone and record, what they're doing, what they're going into. You have the right to look at any document that they may have and find out exactly what it's asking for and where you can look for it. But don't try and stop them. What has to happen afterwards is that, if they take documents and they're not supposed to have them, they may not be able to use them. They'll have to return them, but you don't want to get yourself into any trouble, like assaulting a police officer or something like that. And then just the second one, I would say the social worker or the healthcare provider in this who has, wants to act on their own code. Well, it's fine for you to have your code, but if the person's going to follow through, I would say before they do anything that they should be calling their malpractice carrier.
David, thank you, Chris.
This is such a rich area. Just two quick points, and not to blow everyone's mind. One of the other things the Office of Civil Rights, the HIPAA folks, have recently reminded us is that the HIPAA doesn't protect individuals' health information when it's on a personal cell phone or a tablet. So this should be a stark reminder to everyone to make sure that PHI is on HIPAA compliant platforms and only those platforms, number one. Number two, we make these decisions, we're informed about our obligations under HIPAA. What is the sophistication level of our business associates? What is their policy? What is their level of awareness of these legal changes? These are all kind of knock-on questions we need to begin to ask ourselves.
Amen. Amen. And I would add just a couple other points that occurred to me as the two of you were talking. And tell me, Chris and David, if you have a different opinion. But in my opinion, if there is one of these sort of contentious exchanges with somebody seeking your records, number one, I would be very careful about documenting exactly what happened, contemporaneously. As soon as it happens, I would write down your understanding of what just happened, because that note could end up being quite relevant. Number two, if circumstances permit, you're having some jawboning with somebody who's insisting on seeing your records, my instinct, and David and Chris, I'd like to know your thoughts. My instinct is to try to say, hold on a moment. I'd like to bring a colleague in with me. Now, in other words, I want a colleague to witness this encounter so that it's not just he said, she said, my word against it. I want a colleague who's reputable, who's going to witness what's happening here. Okay, my attorney colleagues agree.
I agree. The only thing that I would also say is that if somebody's being forceful while they're there, also contact your agency's attorney or your individual attorney. Could be important at the time too.
Absolutely.
And get it in writing.
Yep, you got it. Okay, let's move on. So I want to talk a little bit about circumstances where the social worker is providing services to the pregnant 16-year-old, the pregnant 17-year-old. Now, this gets really tricky because, of course, the social worker who's talking with this minor, whose parents, by the way, may not know about the pregnancy. The minor may not want the parents to know about the pregnancy for all kinds of reasons. This gets tricky and sticky because HIPAA generally, notice the word generally, allows a parent, and I'm including guardian when I say parent, to have access to the medical records about his or her child as his or her minor child's personal representative when such access is not inconsistent with state or other laws. So Chris and David might want to say something about that later. Now, those of you who provide services to minors generally, I mean, apart from abortion-related issues, you know that there are times when parents want to see your record. They might be involved in a child custody dispute. I've seen this happen many, many times where parents want to see the clinical records retained by a social worker who serves a minor child. So there are several situations when the parent would not be considered, in my opinion, would not be considered, oh, by the way, and parents generally have access to those records. And I always tell social workers, if you're serving a minor, write every word, assuming the parent is going to read those words someday. Now, most of the time they won't, but I like to prepare for that possibility. Now, in my experience, there are three situations when the parent would not be considered the minor's personal representative under HIPAA regulations. So, for example, when the minor is the one who has the authority in New Jersey, in Tennessee, in Oregon, wherever, under that state law, when the minor is the one who has the authority to consent to care, and the consent of the parent is not required under that state's law or other applicable law. And social workers need to know that these laws vary tremendously state to state. There's no one-stop shopping here. Got to know the local law. There's some states that permit minors to consent to substance use disorder services, and the state right next door does not. One state might say the kid can consent if the kid is 12 years of age or older. The state next door might say 15 years of age. The state next door to that might say it's up to the social worker's clinical judgment as to whether disclosure to the parent would put the minor in harm's way. Number two, another one of the exceptions. When the minor obtains care at the direction of a court or a person appointed by the court, so a parent wouldn't typically have access to the record then. And then three, when and to the extent that the parent agrees that the minor and the healthcare provider may have a confidential relationship. So, Chris, David, don't know if you have an opinion on this one, but I advise social workers who provide services to minors, where some of these issues may come up, to have parents sign a document, basically saying they agree that they're not going to access the record. Now, they may change their mind later and they may fight that, but I think it makes sense to have them sign that document if they're willing. It adds a layer of protection. Chris, David?
Well, I know that in New Jersey, we do have statute 9:17 that addresses number one and specifically carves out exceptions to, getting consent, that a minor can consent to care for reproductive health as well as abortion care. So I know that we have that in here. I'm also thinking that I recall, not directly related to this, but there was a matter, I believe it was out of New Hampshire, which under HIPAA, they set forth that the parents would not have a right to access information. I think a guardian ad litem was appointed, and based
So I can
on,
tell you the case. It's Berg
Yeah.
versus Berg. Berg versus
Right.
Berg in New
Right.
Hampshire.
yeah,
Right.
yeah. So it is very complicated when minors are involved. I think you covered it all. I don't know if Dave has anything to add to that. I just again, get things in writing, talk with parents, and know what your state allows and doesn't allow. I found over my career in talking about these things that a lot of times people don't fully understand the extent that minors, what their rights are and what their rights aren't, what the parents' rights are and what the parents' rights aren't. So,
And they vary tremendously state to state. Dave?
Yeah, I'm a big believer in your working agreement with your clients to set forth the important exceptions and limits to confidentiality. Get it in writing, get it signed by everybody so they can't be heard to complain. And moreover, you're educating people. But this is a confidential relationship, but there are exceptions to confidentiality. Here's what they are. And it's a way of kind of previewing this issue, so it makes the parents less likely to demand it because they've acknowledged that they understand they don't have a right to it under New Jersey law in this case.
Exactly. And too often I get involved in cases where social workers don't have anything in writing with parents acknowledging this. So I just want to quickly point out the third and fourth bullet points. And these bullet points come from the Office for Civil Rights Guidance, Department of Health and Human Services. So the third bullet point, so even though there are these exceptions, even in these exceptional circumstances, the parent may have access to the medical records of the minor related to this treatment when state or other applicable law requires or permits such parental access. It would be explicit in state law, for example. Parental access would be denied when state or other law prohibits such access. If state or other applicable law is silent on a parent's right of access in these cases, the licensed healthcare provider, social worker, may exercise his or her professional judgment to the extent allowed by law to grant or deny parental access to the minor's medical information. Then the fourth bullet point, which is a kind of an extension of this, a provider say social worker, may choose not to treat a parent as a personal representative when the provider reasonably believes, in his or her own professional judgment, that the child has been or may be subjected to domestic violence, abuse, or neglect, or that treating the parent as the child's personal representative could endanger the child. So, Chris or David, anything on that, or shall I move on? Okay. So, here's another narrow circumstance, but I think it's important to acknowledge this, because I've been involved in cases where you have, say, a 16-year-old who's pregnant, doesn't want the parents to know for whatever reason, wants to terminate the pregnancy, and struggles with substances. The kid's life is complicated. And that minor is receiving services in a program specifically designated as a substance use disorder treatment program for adolescents, high-risk adolescents. So here you have a federally assisted, so the law requires federal assistance, federal funding, substance use disorder treatment program, adolescent who's pregnant. And there, social workers need to know, in addition to HIPAA, they need to know, and I'm sure some of you are aware of this, a very strict federal regulation, Title 42. In the federal regulations, there's Title I, Title II, Title III. Title 42 is where the public health regulations, most of them are. Part 2, referred to as the confidentiality of substance use disorders treatment regulation. And in that regulation, I can tell you exactly where it is. It's in section 2.14, if anybody's keeping score. In section 2.14, there is specific language regarding disclosures to parents without a minor's consent. But I've been in cases where social workers didn't know this existed and that it applied to them, or they misunderstood the language. So I just want to read you one sentence after the bold italics there. If a minor patient acting alone has the legal capacity under the applicable state law to apply for and obtain substance use disorder treatment, this is a pregnant teenager, any written consent for disclosure under this regulation may be given only by the minor patient. So I've lost count of the number of social workers who have said to me, when I've said, how do you interpret this? They say, well, that means the minor controls the information. The minor controls whether the social worker can disclose this to the parent. And in my opinion, David and Chris, feel free to weigh in. In my opinion, that's not what this says. It's not what this says, because the first word in that sentence, the 2-letter word, is if. If a minor patient acting alone has the legal capacity under the applicable state law, then the minor controls. The point being, then you got to find out what New Jersey law says and what Maryland law says and what Illinois law says. This does not mean the minor automatically controls that information. Chris, David?
Yeah, this is New Jersey law adds substance use disorder treatment is to the list of things that a minor can authorize, that they do not require parental or guardian consent.
Okay. Chris, anything?
That, it's not always clear, because while, substance abuse is one of those carved out exceptions to with consent, then the question was, well, what does that have to do with, earlier in 9 that says a parent has the right to the medical records of their minor child. So it is confusing. New Jersey does have another law called the Boys and Girls Keystone Club law, which actually explains it a little bit better, but that refers only to behavioral health services. So it is possible that if, in that particular law, again, I can only talk about New Jersey, but it says that if a minor over the age of 16, basically consents to their own behavioral health with a licensed professional, then the parents do not have a right to access that information. So, there's a lot of things going on. I think 42 CFR also, by the way, just goes and kind of clarifies further down the road, if my recollection is correct, That this is not a blanket, exception that you're 100% protected, if you come into a substance abuse treatment program.
Correct.
Don't read it that way.
Correct. And so, folks, I just want to reiterate, this is another example of a situation where, I can provide my ethics-based opinion, but I think this also requires legal consultation to try to sort out the relationship between first of all, which federal laws are relevant, which state laws are relevant, and the relationship between the federal and state laws. This is complicated. I want to add, before I move on, it's the top of the hour. We've invited you, I know some of you came in a bit late. We've invited folks to put questions in the chat. Helen French is monitoring that, and we will provide time in a bit for those questions or comments, or maybe differences of opinion. So I just want you to know we're allocating time for that. By the way, Helen, is there anything that jumps right out that you want to address now, or would you prefer to wait?
We can wait, but I wonder, 2 hours in front of a screen is a long time. Any chance that we can take a couple of minutes break, or would that break your flow?
It's absolutely fine. And it's, you guys are in charge there in New Jersey. So I'll use executive authority here. It's 1 minute after 7. We will reconvene in 5 minutes. Now, I know this is risky because in social work, when you say 5 minutes, that gets translated into 10, but I really mean 5. So it's now 2 minutes after 7. We'll reconvene at 7:07. Okay? We will resume in 2 minutes. 2-minute warning, as they say in sports. 2-minute warning.
We do have a couple of questions for when people come back, if you have time, Dr. Rima.
Absolutely. Absolutely.
There are some interesting questions in the chat. Don't know if we have all the answers, but interesting.
Great.
concerns.
All right. So we'll resume in just a minute and 1-minute warning, and then we'll take a couple of questions, then resume, and we'll take some more questions and comments toward the end as well. All right, so as promised, 7 after the hour, and let's resume. And why don't we spend a few minutes taking some of your questions, your comments, and Helen, I don't know if you want to raise them, or Chris, you said you saw some. I'm not monitoring the chat because I'm sort of running this thing. So either one of you or David want to point out questions in the chat?
Yes, somebody said, is it unethical to not put an abortion referral in my notes?
Is it unethical? So I'm going to get to documentation later, but may as well deal with this now. Would it be unethical to not put in the notes an abortion referral? So David, Chris, want to comment on that? And I'm happy to weigh in as well.
I don't know about the ethics of it. I'll defer to people like Dr. Reamer. Legally, I'm concerned about whether that impacts the standard of care, and whether you are offending regulations governing how records are to be maintained. I'm not suggesting this, I'm not advising this, but I suspect people may consider, having the abortion alternatives, the healthcare options in states that aren't as friendly as New Jersey or New York, may try to get those out of their electronic records and into their paper records. It's a question that really needs to be looked at in more detail.
Thank you, Chris.
Yeah, one of the things, I guess, the language in the Code of Ethics, as well as at least in our requirements for documentation for licensure in the state of New Jersey, I mean, they make reference to words like, document all relevant information. And so it doesn't say, first of all, that everything that's discussed has to be documented. It talks about, reflecting, what was discussed in the session. Okay, so I think that does leave a little bit of wiggle room. I also think that social workers can use our skill of reframing a document.
Exactly. So this is a situation which, and again, I'm going to broach this in just a bit because I want to focus on documentation issues. So one of the things I argue is that there are instances in order to protect a client, and I'm always thinking, who might have access to these notes down the road? I believe the phrase confidential record is fiction. I think the phrase confidential record is fiction. I can rattle off many different ways in which third parties have access to our notes by virtue of court order, contracts, all kinds of things, client requests. And so I argue that sometimes vagueness is a virtue. That's a phrase that I like. Sometimes vagueness is a virtue. So I would argue that made a referral for health-related consultation. Works for me. Now, I also think sometimes vagueness is a disaster. In other words, every coin I know has two sides. Vagueness can be a virtue, but vagueness can be a disaster. So if my client is engaging in suicidal ideation related to this unplanned pregnancy, I can't be vague about the suicidal ideation. I don't think I can. I think there's a sort of a threshold there when we're dealing with health and safety risks where we can't be vague. But that's my opinion. Chris, David? Okay, thumbs up from Chris. We'll see which way Dave's thumb goes. Okay, good. Okay, so let's move on. Oh, Helen, did you have another question or two?
Yeah, it's a point of clarification, actually. So duty to warn cannot be used against a social worker for not breaking confidentiality in cases of states that do consider a fetus a person. So it's a point of questionality. Are there any legal ramifications we can face if it is proven we did not report or provided resources?
Well, with the not report, I mean, again, HIPAA does not require disclosure. HIPAA permits disclosure. So that's an important distinction. I don't know, Chris or Dave, if you want to say anything about that question.
Dave, I mean, this is one of the questions when I saw it, I'm like, this is a tough one because when you're working in these states that are saying a fetus is a living thing, and then, you can kind of take it to, well, if somebody's going to kill the fetus, then you have to warn somebody to prevent the harm to the fetus. But I don't think we've kind of even really got there because if when we go there, we're going to have a lot of other stuff going on, and people have been talking about it already. When do you start paying child support? All of these things. So
Yeah.
And to complicate it even further, some states, with regard to duty to warn, or the phrase I prefer is duty to protect, warning is one option, but not the only option. Even in the states that address so-called duty to warn, duty to protect, some states mandate disclosure. A lot of states permit disclosure, but don't mandate it. So again, got to know local law. David, anything on that?
Yeah, this issue is being played out in 50 different states. And some of it's interesting, some of it's terrifying, some of it's ridiculous. A woman in Texas recently challenged a speeding ticket or a ticket for driving in the HOV lane. Her defense was, well, I'm pregnant and I have this other person under Texas law riding with me, so therefore I'm entitled to drive in the HOV lane. That's kind of amusing, but it's just a small illustration of how all these interesting things are going to play out. I am hopeful that prosecutors and judges will look at this recognition of personhood on the part of a fetus in those states that do that within the context of the intent of the law in question, and not turn us upside down and crazy. But that's my editorial.
Right. And a lot of this is completely unsettled. These legal guidelines are going to evolve. We've only had a month to deal with a lot of this, and stay tuned. Stay tuned. All right, Helen, do we have time for one more?
There were comments at the beginning of the presentation that maybe the inclusive phrase of pregnant individual.
Absolutely.
All right.
Right. Pregnant woman, pregnant person, right? Right. So we know this is complex and language matters. Absolutely. Absolutely. All right. So we'll set aside some time toward the end as well. We've got about 45 minutes. So let me just continue with this. So technology. So as I said at the opening, I was privileged to have chaired the national task force that wrote the Code of Ethics in the mid-1990s, when so much of the technology that's now pervasive in our lives did not exist. And recently, as I said earlier, several colleagues and I had the opportunity to update the NASW Code of Ethics. We added several dozen technology-related standards, and David has been very involved over the years in discussions of that. We've collaborated. So on this slide, slide 12, I've listed some of the concerns I have, I'm not the only one, others as well, about the kind of data that could in principle be used against our clients. So-called geolocation data. So for example, if our client who's pregnant and is making a difficult decision about abortion has GPS auto location on their smartphone, they brought it with them. They didn't leave it home. And it can track that they visited this Planned Parenthood office or what have you. Smartphone and computer apps and data. Some of you have probably heard about this. Anxiety among social workers and others that some individuals may have on their smartphones, menstruation trackers, health apps, a record of their internet search history where they're trying to find abortion-related services. That's creating a digital trail. Credit cards that they're using to pay for services, well, they can be subpoenaed, as opposed to, for example, using prepaid gift cards, which don't have a digital trail. Some of you may be familiar with the phenomenon known as location data brokers. What's a location data broker? This is an enormously powerful phenomenon. These are companies that sell GPS geolocation data. It could be from the weather app on your phone. If you're a person of faith and you have a prayer app on your phone, I will show you an example of one company that is known to do this. This is just one. Better customer experiences through the ethical use of data and technology. What do? We gather data from all kinds of sources, and then we sell it to companies that are interested. And so I know that there's a lot of anxiety among social workers and healthcare professionals about location data brokers. Text communications, email communications. David earlier referred to the importance of encryption. I know a lot of social workers who, for whatever reason, are not using smartphone platform software that's encrypted when they exchange text messages or email messages with clients. My opinion is we have to be using this encryption software when we exchange messages. The possibility of voicemail messages that leave a trail, online posts, all these websites where people post comments about, anybody have any advice about where I can go for this, that, or the other service? You know, this Nextdoor app, that kind of thing, website rather. Notes in electronic health and medical records. I want to say a little bit about, quote, psychotherapy notes, unquote. Because I think this is really important for social workers who have sensitive discussions with pregnant persons. So, as I hope all of you know, but maybe some of you don't, within HIPAA, there is a particular section that defines the term psychotherapy notes. And psychotherapy notes under the law have special protection. So hypothetically, a social worker could have in the psychotherapy notes more sensitive information that generally would not be available. So what's a psychotherapy note? And for those of you who like this sort of thing, this is Title 45, Code of Federal Regulations, Section 164.501. It's embedded in there. Generally, HIPAA applies uniformly to all protected health information, PHI, without regard to the type of information. But there's one exception to this general rule for so-called psychotherapy notes, and they have special protections. And the HIPAA privacy rule defines psychotherapy notes as notes recorded by a healthcare provider, social worker, who's a mental health professional documenting or analyzing, this is the exact language from the law, documenting or analyzing the contents of a conversation during a private counseling session or a group, joint, or family counseling session, and that are separate. Notice that word separate. They've got to be segregated from your typical session note. If it's an electronic record, it'd be a separate tab. If some of you are still using paper records, it'd be like a separate section in the paper record, an envelope, something that segregates it, separate from the rest of the patient's medical record. HIPAA uses the word patient, not client. Psychotherapy notes do not include any information about medication prescription and monitoring, counseling session start and stop times, modalities and frequencies of treatment furnished, or results of clinical tests, nor do they include summaries of diagnosis, functional status, treatment plan, symptoms, prognosis, and progress to date. Now, so point number one that I want to make, and then I'll hand it over to the lawyers, is that including some of this more sensitive information in a psychotherapy note as defined by HIPAA adds a layer of protection. But, B-U-T, and it's a big but, I've met social workers who think that that's in like Fort Knox. Nobody would ever get those notes related to the abortion discussion. They could still end up being disclosed. Why? Because in an adversarial proceeding, a lawyer on the other side of the case might subpoena a social worker's notes and specify in the subpoena, called a subpoena ducis tecum, including but not limited to, there's a long list, including any psychotherapy notes. And then the lawyer acting on behalf of the social worker files the motion to quash saying, we're not handing that stuff over for the following reasons, blah, blah, blah. And then a judge asks to see those notes in camera, meaning in chambers. And a judge, I think David and Chris will agree, might decide to order disclosure of those psychotherapy notes, even though they generally have special protection. So David and Chris, so I say on the one hand, be aware of psychotherapy notes as an option, but beware, because it's not foolproof. David or Chris?
Chris?
Well, yeah. Well, I actually have a question. I mean, when I look at this and I look at HIPAA saying basically that you have to include in your record that last paragraph that starts with psychotherapy notes do not include any information about medication and so on. That's what HIPAA requires you to have from there on. Many states, including New Jersey, do require that you have in the file, some notes about the session.
Mhm.
But these notes, the psychotherapy notes that HIPAA describes, they describe it as those are the notes that providers use that aren't intended to be the final version, that aren't intended to be disclosed, that this is the provider, just jotting things down for their own purpose and their own memory.
It's
And
a memory
so,
jog, as we said.
yeah. And so I've often wondered, are those the kind of notes that have to be kept? Or if they belong to me as the provider, can't I destroy them?
I think, in my personal opinion, obviously I'm not a lawyer, but my opinion is you can destroy them. You're not obligated to keep them. And if you have them, you can destroy them. You might be asked under oath, did you ever have them? Where are they? I destroyed them. Why'd you destroy them? You go down that road. So Chris, as to your point, what I have said is that the notes that are not psychotherapy notes, session notes, can be fairly brief, often, unless there's a crisis, fairly brief, discussed parent-child relationship, coping with conflict, something like that. But
Like
then
a
the
SILT note.
psychotherapy note, the session note, this psychotherapy note might get into the weeds a bit more with regard to the battles they're having over the kid being pregnant. So that's the distinction I make. But David, what do you think?
I agree with you, Rick. I think we're all kind of on the same page. It's a question of degree. I think the best way to protect the abortion-related content is to put it in the psychotherapy notes and to engage in vagueness, appropriate level of vagueness.
Exactly. Because I would be hesitant to use the A word, abortion, even though the psychotherapy note gets a lot more protection, there is still the possibility that that will end up being disclosed due to court order, right, Dave and Chris?
Yeah, if you're keeping them, it's
Yeah.
possible.
Right. So even there, I think vagueness is a virtue. So 4 documentation issues that I think social workers ought to think about. So we've already talked about this. I won't spend much time on this. The judgments we need to make in these circumstances about when to be vague. Quote, client discussed important personal decision or a health issue, something like that, as opposed to client discussed feelings about planned abortion, right? I would lean toward the former. Now, we haven't mentioned this yet, the 21st Century Cures Act. Now, this is not old. This is last year, the 21st Century Cures Act, which in many, not all settings, means that clients can get access to their electronic records, if there's a portal, without delay. I forget the exact language, but the implication is without delay. And what that means is, at least in my experience, more and more clients are getting access to your notes. And if they so wish, they can share your notes. They can print them out. And that means your notes may be in the possession of a third party, third parties. And that means that your carefully worded notes might be read by a lot of people other than you. And I think the 21st Century Cures Act widens the net with regard to the number of people who hypothetically could be reading your notes. I'm not saying that's a huge risk. I just think it's a risk. Let me just finish these points and hand it back to Chris and David. Then there are shadow notes. So if we were in an auditorium together, I'd ask, how many of you keep what we call shadow notes or informal notes, personal notes? Not necessarily psychotherapy notes as defined by HIPAA, but you've got that manila folder in the middle drawer of your file cabinet where you sort of keep informal notes regarding client X and client Z and client D as a memory jog to keep track of details that you're not comfortable putting in the case record, electronic or paper. And so I've met social workers who think, well, if my records end up getting subpoenaed and I have to disclose them, I don't need to disclose those shadow notes, which might have ramifications for my client because I've got some pretty sensitive stuff in there. And I say, from my opinion, from my point of view, not so. A smart lawyer, and most lawyers I know are smart, almost all of them, they'll put on the subpoena case records, clinical records, including but not limited to any informal personal notes, because smart lawyers know that some social workers keep those things. And those notes may not meet the definition of a psychotherapy note. And those notes may have to be produced and could end up being used against the client or a social worker. So I'd be careful. Now, there are a couple of exceptions. Unless it's changed within the past week or so, Illinois still has a law protecting these so-called shadow or personal notes. Most jurisdictions don't, but Illinois is one example of a jurisdiction where a social worker can keep those informal notes and they don't need to be disclosed. They're protected. But most states, to my knowledge, don't do that. And then there's the issue I already mentioned, so I'm not going to repeat it, but I want it on this list. For those of you who provide services to minors, all those complicated, very complicated issues around parents' access to your records regarding their minor children, where you may have some information about a pregnancy. Chris, David?
As a recovering litigator, I want to share a couple of thoughts with all of you. Number one, you should assume that when this heads towards litigation, you are going to get in the discovery process either a subpoena, document demand, interrogatory, or all of them. You're going to get demands for documents, including but not limited to drafts earlier versions. Tell me about your record keeping system. Tell me about your data storage system. We want all drafts, all preliminary notes, etc. So just by virtue of calling them something else and keeping them in another place is not going to insulate you from a demand for them. That should be your working assumption. Number two.
Yeah, if I can just say, if it looks like a duck and it waddles like a duck and it's yellow and it's got a beak, it's a duck, even if you call it something else.
The second point I want to make, and it's really important, is you can't have a spring cleaning when the lawsuit gets filed in anticipation of these discovery demands. Okay, destroying evidence is, at least in New Jersey, it's a little bit unique. It's called spoliation. Okay, you spoil the evidence. And in New Jersey, spoliation is both a criminal offense and a civil offense. So you can be sued civilly and have a criminal proceeding brought against you. Don't do it, avoid it.
And I hope I get the wording right here, lawyers. And if you alter, destroy records, spoliation, not spoilation, spoliation, then the court, jury, can reach an adverse conclusion based on those actions, correct?
Yes, sir.
Okay, it can be used against you in all kinds of ways. Chris?
Yeah, going kind of back to our discussion of HIPAA and what I'll call, just for clarification, the HIPAA notes, the notes that are not in the file, okay? I see them as these personal notes, okay? I don't know if I'd call them shadow notes, but I do see the HIPAA notes being, the personal notes. And I agree with David, once you get a subpoena, you do not want to start destroying things. But I think if you have a process on a regular basis that after you write your
Correct.
official note for the file, that you destroy the personal note, I don't think that can get you
I
any.
agree. I
No.
agree.
But it has to be
I agree.
consistent, part of your regular process. That's highly defensible.
And I've been in court cases where legal counsel says, here's how you're going to answer that question. Usual and customary practice, habit, right? Right. So agreed. Okay. This term abandonment, again, lawyers use this term. If you take a look at section 1.17 of the NASW Code of Ethics, we actually use the word abandon in there. That was section 1.17 refers to all the ethics standards pertaining to termination of services. And I think there's several key questions here. First, am I obligated as a social worker to serve clients who request abortion-related information and counseling? So I understand, at least based on the data, that most social workers would want to help a client who is seeking abortion-related information and counseling. But I have met some social workers, again, based on the data, it's a minority out there, who would not feel comfortable providing abortion-related information or counseling because it's contrary to their religious beliefs, what have you. And in my opinion, I may not agree with them, but I do believe social workers have a right to say, I'm not the right person for you. I need to refer you. I'm not comfortable providing that kind of information. That may make some of you uncomfortable, but I believe a social worker has that right. Let me finish these and then turn it to my colleagues. What steps should I take if I'm not comfortable working with a client who requests abortion-related information and counseling? What NASW Code of Ethics standards are relevant? So I've summarized them here on slide 16. I won't read them, too tedious, but section 1.16 in the code, and I should add here as a footnote, many, but not all states, in their social work licensing law, sometimes it's referenced in statute, sometimes it's referenced in regulation, sometimes it's referenced in both, an explicit reference to the NASW Code of Ethics. So it's embedded in the law. Not all states do that, but many do. Section 1.16, referral for services. So the way I interpret 1.16a is that if I don't feel like I'm the right person to provide abortion-related information or services to my client, I need to refer that person. I'm obligated to refer that person. And I'm supposed to do that. I shouldn't refuse to do that. I'm supposed to do that. I shouldn't say to a client, you're on your own, sorry. Section 1.17, as I mentioned, has to do with termination of services. And so hypothetically, if a social worker decides I'm not the right person to be assisting this client because of my faith or what have you, my personal beliefs, then, as it says in B, I can't abandon my client. There's that word. I can't abandon my client who still needs services. I can't withdraw services precipitously. I've got to make appropriate arrangements for continuation of services. So, Chris, David, anything on these issues? Let me go back up to that slide. Your thoughts about that from a lawyer's point of view?
I think I agree with you 100%. That's,
Okay.
we've dealt with that. I know I have had, situations where people have worked. Yeah, so I agree.
I agree. I think if, part of the social worker's role is to be a resource person. And I don't see anything changing that. But if you have deeply held personal beliefs that mandate that you don't provide this information, number one, maybe you want to rethink your career, but secondly, I think you need to empower your prospective clients with knowing your position. So I think you need to be forthright at the outset that, these are the beliefs of our practice, so that people can be guided accordingly and they don't go down that road with you only to then learn of your particular sensitivities.
And let me just add this little footnote. Thank you, Chris and David. A number of years ago, I was an expert witness in a case where a social worker worked for a faith-based agency. The faith-based agency was on a list of agencies, some faith-based, some entirely secular, that on a rotating basis accepted referrals from city agencies when clients needed behavioral health services. So this social worker gets a referral. She's working for a faith-based agency. And there was an older adolescent who was pregnant. The faith-based agency, as a matter of policy, prohibited that social worker from providing any information about abortion, not just abortion, but all the options available. You can parent, adoption, terminate pregnancy. What are the options? This social worker was prohibited as a matter of agency policy from providing any information or referrals for abortion. The social worker believed that as a social worker, she was obligated not to encourage abortion, of course not, but to explain all the options available and to help that client think through her options. That case went to court because there was a conflict between the social work ethical standards and agency policy. And I was the expert witness on the side of the agency, not the agency rather, but the social worker, not the agency, but the social worker. And our argument was that that social worker had a fundamental ethical duty to provide information, unbiased information. And the fact that this agency was simply on a list of agencies that accepted referrals from the city, some secular, some not, it was just kind of luck of the draw that this client ends up at a faith-based agency, didn't say, I want that faith-based agency. Long story short, that social worker prevailed. I was very pleased about that. But that's an example of an ethical dilemma with legal implications.
Rick,
Chris?
was it because of the connection to government? Was
Yes.
that? Yeah.
Yes. Yep. It's kind of a narrow issue, right? Complicated, but it's a good illustration of how legal issues and ethical issues can intersect in these scenarios. So we've got about 19 minutes. I want to do a couple of other things and open it up to more comments and questions. Helen, so that's going to come in just a couple of minutes, and Chris and David's additional comments. Some of you know this phrase. It may be new to some of you. These are complicated situations, very complicated situations. And what I've discovered in my career is that ultimately, if social workers' judgments are challenged with regard to any of the issues that have come up this evening, the measuring rod is going to be the standard of care. This concept has been in the law in the US, also in England, but in the US since the late 1800s. Defined differently by different states, but generally like this: what a reasonable and prudent, meaning careful, cautious, professional with the same or similar training should have done under the same or similar circumstances. Now, I'll be the first to admit that with regard to some of these complex issues related to documentation, related to disclosure of confidential information, social workers themselves may not agree on what the standard of care is. There may be reasonable differences of opinion on some of these issues. But in my experience, this is the measuring rod. When I'm an expert witness, I am always asked by attorneys whether I think the social worker met the standard of care or fell below it. But I have learned in my career that there are 8 things we can do. I wish there were 10, because that's more like the commandments, but I've only got 8. 8 things we can do in these complicated situations when we may not be certain about how to handle these complex situations. And I know some of this is painfully obvious, but I'll say it anyway. And I'll do this very quickly so we can get your comments and questions. The importance, so I call this the procedural standard of care. If we don't agree on what I call the substantive standard of care, then I say we revert to what I call the procedural standard of care. That is, when reasonable, prudent social workers do not agree on the substantive standard of care around these issues we've discussed this evening, then a reasonable and prudent social worker would consider 8 things. And I spell this out much more fully in a book that I wrote on risk management. The importance of consultation. Don't be a solo pilot. Run this by seasoned colleagues. And if you're in an agency, not in private practice, supervisors, to think these things through, and please document those discussions. Be sure you know what the current NASW Code of Ethics says, not the one that was in effect when you graduated from Rutgers, because that may not be the one that's in effect today. Because you're held to the one that's in effect today. National practice standards. I mentioned that recently I was asked by NASW and the Association of Social Work Boards and the Council on Social Work Education, the Clinical Social Work Association, to chair a task force. Dave knows something about this. To develop comprehensive standards, practice standards, not code of ethics, practice standards regarding use of technology. And this evening, we've highlighted ways in which digital trails, digital footprints, electronic records could be relevant in these cases. And if you're not familiar with those national practice standards, I encourage you to go to the NASW website. Just put in the search engine, NASW practice standards. The first one you'll see on the top left are the relatively new standards regarding social workers' use of technology. Number 4, relevant laws, policies, and regulations. Heaven knows this evening, multiple times, Dave and Chris and I have talked about variation among state statutes, state regulations, the relationship between state law and federal law. It's complicated and it is evolving. This is a moving target. Relevant literature. If there's litigation, in my experience, there's a pretty good chance lawyers are going to bring in literature that's relevant to social workers' management of confidential information, social work documentation as evidence of standard of care, legal consultation when necessary. For those of you who work in healthcare settings, especially, you may be fortunate enough to have access to an ethics committee. Those of you in private practice, no. But if you work in a hospital, healthcare clinic, there may be an ethics committee that you can consult. They're not going to tell you what to do typically, but it's a resource for consultation. Those of you who are NASW members, Helen, that's a plug for NASW. Those of you who are NASW members have access to ethics consultation. It's a member benefit, but you got to prove that you're a member to get that benefit. Another reason to join. By the way, the first ethics committee in the US was established in New Jersey because of the Karen Ann Quinlan case in the 1970s. And that led to the creation of ethics committees throughout our land. If you have one available, please use it. And then, as we've said a number of times and in different ways, documentation, 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 it is so key. So often, the outcome of litigation cases that I get involved in, licensing board cases that I get involved in, the outcome is determined by the quality of the documentation. That's not hyperbole. It's so important. And finally, oh, by the way, here are some resources. Right? We've touched on most of these this evening. Your malpractice insurance. If any of you work for an agency and do not have your own coverage, my opinion, get your own coverage. Even if your employer has good coverage, that's likely to cover you in most instances. But notice I said most, because there could be a conflict of interest with your employer. And your employer's policy might not allow for separate counsel that they're going to pay for. If you're named in a licensing board complaint, and I hope you're not, your employer's policy may not pay 10 cents for legal representation in a licensing board case, but your policy will. I've been in cases recently, in a case in Illinois that I testified in, where the jury verdict exceeded the cap on the employer's coverage. And the plaintiff's lawyers, they're obligated to go after the practitioners as individuals. I want, as lawyers say, a belt and suspenders. I want a raincoat and an umbrella, just in case. And if you leave your job, sometimes I've seen questions about whether the employer's policy is going to cover you as a former employee. That gets complicated. So, David, Chris, anything you want to add before we open it up to our colleagues for the last 10 minutes or so?
Well, two things come to mind. One, you sort of already addressed, but it's the idea of this is new. There's a lot of questions that you'll have that we don't have the answers to, because the legal process is, a law is passed and then it may end up in a lawsuit. The court interprets the law, then publishes an opinion, and, so it's new and the answers are not always there. The other thing, just to point out, that this Dobbs decision also may open the door in so many other different areas, not just the issue of abortion, but of birth control, of the rights of LGBTIQ plus folks. And Clarence Thomas has already signaled, that he wants to go further on this. So another reason why we should care about this. So that's the only things that I have to add.
Thank you, Chris. David? So David appears to be frozen. We'll see if we can get him back. Not his personality. He's not a frozen kind of guy, but I think he's back. David, are you there?
Yeah, I'm here.
Okay, please. Any closing argument, counsel?
No arguments. I do want to echo one of your last points. You know, and my legal practice is really limited to defending and advising New Jersey social workers and other mental health professionals. It has to do with the standard of care. As Dr. Reamer's slide indicates, it's not found in any one place, but a variety of places. The best way to make sure that we are adhering to the standard of care, in my opinion, is to be actively engaged in your profession. Be an active member of NASW. Actively review the social work publications. Track these issues impacting social workers in the news. These are all ways that you can heighten the odds that you are in compliance with the applicable standard of care. Thank you very much.
Agreed. In a picture, worst case scenario, being cross-examined by an aggressive litigator, which, by the way, is often a redundancy. No offense, lawyers, right? Aggressive litigator is often a redundancy. You don't need both words. An aggressive litigator on the other side of the case, opposing counsel, who has you on the stand and asks you to summarize what the NASW Code of Ethics says regarding an issue under discussion in that case. And that attorney's goal may be to try to show the court, the jury, that you don't know the code. Sometimes lawyers know our code better than we know our code, sadly. A lawyer on the other side of the case might ask, are you familiar with the NASW practice standards regarding technology, whatever? The lawyer has found that stuff. They did their homework. And they're hoping, because they're on the other side of the case, that you say, no, I'm not familiar with that. And they use that to try to challenge your credibility. I've seen it happen multiple times. So I'm just echoing what David said, just being on top of the resources in our profession. I'm not here to sell NASW, but I will say being a member of NASW is one of the best ways to do that because you have access to so much that can shift the needle in your favor, big time. So Helen, before we close in 8 minutes, other questions or comments?
Yeah, please put up your virtual hand if you have questions and or comments so we can address them. A lot of very helpful information given, but I think sometimes it can be a little bit overwhelming. And also, like you say, this is so new that things are developing as we go. Doug, you had a question about the complications of financial responsibility and insurance company disclosure. Did you want to come on mic and ask your question?
Sure. Doug, why don't you unmute and ask it so we all fully understand what you're inquiring about? Introduce yourself.
I'm asking, before we went on break, I'm asking about the second half of that slide that was up. It never got addressed, and I think it has a lot of complications regarding legal requirements of insurance companies in terms of requesting, parent signature consent. If it's not required by the service provider, does the insurance company then release whatever kind of payment they made to that particular facility to the parent, saying we paid this much, towards.
Oh, I see, like the EOB kind of thing.
Yeah, that second half of that slide, there's a lot of complications there. And unfortunately, we didn't get back to that after the break.
Right. So Chris or David, do you want to say anything about the likelihood, if I understand Doug correctly, that parents who didn't learn of these details from the social worker might add up 2 and 2 and get 4 when they get the EOB from the insurance company? Doug, did I get that right? Okay, well, you're muted. But David,
yes, that's just one of the complications there.
Yeah.
More, but that's one of them. Yeah.
Okay, so David, Chris, anything you want to say about that?
I mean, it's certainly possible. I recognize that nightmare scenario. You can control what you can control, but that is truly beyond your ability to control. So I have no great insights beyond that.
Chris, anything?
That comes up sometimes when you have the minor who's asking for services without needing parental consent, and the question being who's going to pay. That's the only time I've really kind of seen it. I suppose a parent could object to the services. And, the practitioner, look, has to decide, is it worth fighting or is it worth saying, here, take your fee back? I can tell you from working in a private practice in which we did a lot of court-related work in child custody, and there's, when you've got custody battles or divorce or whatever, nobody's ever happy. And so there have been times where, the unhappy parent or litigant has come and, threatened all sorts of things. I paid you for this and you didn't agree with me and you ruled against me or whatever. And sometimes you just gotta either haircut, as they say, and say, fine, have your money back. It's not worth fighting you on this.
But if a minor wants to get behavioral health, substance abuse, or reproductive health services and doesn't want their parent to know about it, if the insurance company releases an EOB, they find out about it.
They could very well. They could very well. And Doug, I wish I had something more satisfactory to say, but I think that is the reality. And so I sort of echo what David said. We can only control what we have control over, and it's unfortunate. Helen, what else do you have?
Yeah, I'm going to say your name wrong, so I apologize in advance. Dahania?
Diana.
Okay.
It's more complicated.
Diana, I bet that's the first time you've ever had to clarify the pronunciation of your name.
Never. And that's because you guys haven't seen my maiden name. This is my married name, and you guys get it off easy. But quick fact, just so you remember me. No, it's after Diana Ross. Just my dad didn't know how to spell it, and he phonetically spelled it in Spanish. But I was curious. I'm not sure if I heard wrong. But when we were talking about documentation and we're talking about parents requesting our records, right? I think, Dr. Raymer, you made a suggestion about having them complete a form, a document that says, I'm not going to request the records because it will hurt my child, or if you can revisit that really quickly, because I wasn't able to take notes on it.
Sure. So I'll be very brief. So a lot of social work clinicians who work with minors have like a one-page statement written in user-friendly language, because you don't want to antagonize parents. You can imagine the beginning of it. Talking about how important trust is in a relationship, psychotherapeutic relationship. It's important that your child be comfortable telling me, blah, blah, blah. Everything's confidential. You give some examples of, well, in these extreme circumstances, I would share information with you, threat to self or other, all that sort of thing. And it concludes with, and given that you can appreciate how important trust is, you agree not to request copies of my clinical notes pertaining to your child. So that is the kind of document that a lot of clinicians use. Does that help, Diana?
And whether or not that would be legally binding is another story, but you can
Correct.
just take it back to, hey, remember in the beginning we talked about this, and
Yes, thank you very much.
It has the additional benefit when you have that kind of language. When you have that intake with the parent, if they are objecting to that, if they have
Red
a
flag.
problem with that, God
Red
bless.
flag.
Free consults are wonderful because they're not the right fit for your practice. Better to know that at the outset.
And I see this so often. I've been involved as an expert witness in so many cases that involved a child custody dispute where the parent's agenda is to get hold of your clinical notes, Diana, to use them against the other parent. That is sometimes the agenda. Mommy came home and, I don't know if she was drunk, but she did this and she did that, and dad's attorney wants those records, that kind of thing. So do we have time for one more? I know we're just about out of time. Helen?
Yeah, we're just out. Is there one more question? I saw Mary Beth had her hand up, but then it went down. But put your hand up if we got for one more question.
I could ask, yeah. So I was just curious. I don't know if this is the right form to ask the question, but if anybody is aware of ways that we can help out social workers in states where it's not so, like we have a lot more protections here.
So I'll be brief because I know we're out of time. It's the top of the hour. I'll give you one example. the executive director in Texas. His name is Will Francis. He is so eager to collaborate with social workers who want to be of assistance, because social workers right now in Texas, other states as well, are really struggling with these issues big time. So that's just, Mary Beth, that's just one example. And Will Francis, again, that's his name, may be able to give you names of other NASW executive directors who could be a conduit for your generous offer of assistance. Okay.
Yeah.
So I know we're out of time. So number one, I want to thank all of you for spending 2 hours on a weekday evening wrestling with such difficult issues. I mean, these are very daunting issues. I hope you have found this information useful. I understand it's complicated. There are a lot of situations here where there are no easy answers, but I think so much of this is about a way of thinking when we bump into these issues. It's a way of thinking and analyzing. And I especially want to thank Helen for helping to organize this. I want to thank David and Chris so much for their legal wisdom, their willingness to participate, to share their thoughts and their insights. It's a great illustration of collaboration between the sort of ethics perspective and the legal perspective. And I hope it's been useful. I know we're living in an extraordinarily difficult time. We're facing so many daunting challenges in this world of ours right now in all kinds of ways. And I mean this from the bottom of my heart. Thank you for being a social worker, because, oh my, does our world need us now.
Right.
Back to you, Helen.
Beautiful. Hey, I'm not going to say anything. That was a wonderful way to end the webinar. Thank you for the dream team, Chris, Dave, Dr. Rima, just brilliant, brilliant. Thank you, everyone. We'll be sending out your certificates tomorrow, and I look forward to seeing you and on another webinar, and maybe we will get to meet in person soon, right? It's about time, isn't it? So
wouldn't that be nice? So be well,
I do
everybody.
need
Take
better
care.
lighting. It's true. True. Dave.
Be well.
Bye, everyone. Have a good one.